Thank you very much, Mr. Leach. I know we've debated this point with Ms. Engelbrecht, but I just want to hear you. The respondents, in essence, say your challenge is against an inchoate legislative arrangement. The scheme is still inchoate because the regulations in terms of which it will be implemented are not yet there. And the question that comes to mind is, why should we look at it now until these regulations come?
Deputy Chief Justice, can I answer your proposition in two ways? The first is a factual way, and the second is a principled way. From a factual point of view, Ms. Engelbrecht made the point, and I'm not going to repeat her submissions, but Ms. Engelbrecht made the point that the 2-year window period is not a window period that says when it expires, then you must apply for a license. It says when the 2-year window period ends, if you do not have a license, you're committing an unlawful offence under Section 40. HASA says that the implication of this, from a factual point of view, is that immediately the sections are introduced into law and become effective, there will be a risk that arises. And that risk is one that is going to implicate the funding of private hospitals, health establishments, including maintenance and future costing, decisions that are taken many years in advance. That evidence says that the risk will be such that capital will be moved elsewhere to less risky endeavours, or the capital will become more expensive to accommodate that risk. That's the evidence before the court. And what HASA has demonstrated, therefore, is that if we wait until the regulations, that's not good enough. Because once we're waiting for the regulations, we're still not forestalling the problem. Because when the risk eventuates, then the harm arises, including the diminution of the Section 27(2) rights. And the alternative to dealing with it now, from a practical and factual point of view, would be to have HASA come rushing back to this court once the regulations have been promulgated, or to the High Court for urgent relief. And that, with respect, is not feasible. The legal proposition, Deputy Chief Justice, is this one. I have formulated my address to the court on the basis that in deciding this case, the court is being asked at this stage to decide whether or not the scheme that has been proposed by the respondents, Department of Health and the Minister, whether or not that scheme has been shown to be a justifiable limitation on rights. And that scheme, the entire purpose of it, is geographical relocation. The answering affidavit is replete with instances of that. We've chosen only paragraph 114. I can give you, I counted them, there are about 20 references to geographical relocation in the answering affidavit as being the purpose of the scheme. So this court is being asked to determine a legal question, and the regulations cannot save that legal question. No matter what the regulations are that are promulgated, they cannot answer that legal question of whether or not the department has shown, under the obligation that they bear in terms of Section 36, that their scheme is a justifiable limitation on rights. And one of the principal reasons why the department hasn't shown that is because they haven't dealt with the evidence that has been put up by HASA that shows that actually, rather than enhancing access to healthcare, this will diminish access to healthcare. I know that the court may be becoming tired of me repeating that, but it is crucial with respect, because HASA talks to the fact that we have a problem retaining allied healthcare professionals and healthcare professionals, including nurses. And HASA says that these people are being recruited internationally, particularly post-COVID. Those are the allegations. It runs for about 8 pages across HASA's founding affidavit. And in a 4-paragraph answer, the department says, well, you're relying on the hemorrhaging of health professionals report, which was 2007, and that is out of date. That's their answer. And then there's a bare denial. But they don't address the 2020 COVID epidemic. They don't address the 2022 report. They don't address the factual evidence that HASA puts up of how they are losing nurses on a constant basis to overseas and immigration. And what HASA says is that if you compel somebody to separate from their family and go and live somewhere else to pursue their profession, let's think notionally, if you'll forgive me for giving an analogy from the bar. I'm an advocate, obviously. My wife is a doctor. I might be subject to the Department of Justice's access. I might even have a Deputy Justice, Chief Justice, who requires me to go and undertake an acting stint. In that period of time, I will be absent from my home. I might be living in a different division. Might be living in Bloemfontein or Cape Town or in a labour court in Durban. My wife, on the other hand, might be sent to a rural village. Who looks after my children?
I think you're going back to your submissions that you've made.
Court pleases, Chief Justice.
But
I think I have tried to answer
you
your
have,
question.
yes. Let me ask you a different question. You admit or you concede that the provision of health or the access to adequate, affordable, timeless health care in South Africa is a problem. You make that concession in your written reply, in your written aids. Am I correct?
Yes, Chief Justice, I think that everybody understands and appreciates that that's a problem.
Yeah. And you,
Can I,
do you?
That's access through public health care.
Yes.
Because HASA says the private hospital sector and the private health sector, free of, and I'm going to be blunt here, they say free of the corruption and the maladministration and the inefficiencies that beset and plague the public healthcare system, have stepped in to fill a gap. That's the evidence that HASA puts up. And they say it's not a case of a failing of private healthcare, it's a case of failing of public healthcare.
I see. So, do you understand then you to be saying the role of the minister in regulating healthcare is very limited when it comes to private healthcare providers?
Not at all, Deputy Chief Justice. Regulation of any industry is permissible, both under the Constitution and more generally.
No, but if you agree that the minister does have the power to regulate that, you can't seek to differentiate between public and private healthcare, can you?
No, Chief Justice, the question, I apologize, Deputy Chief Justice, the question that was put to me is whether or not HASA, my client,
Yes.
concedes that access to healthcare is a problem.
Yes.
And HASA in its papers says quite clearly the private healthcare system is a very good and functional system. there is a real problem in access to healthcare in public healthcare. That's where the problem lies, says HASA. Now, the proposition that you, with respect, the Deputy Chief Justice, have now tagged on to that is, does that not mean that the Minister can regulate both public and private? Yes, of course the Minister can. But that doesn't solve the question or answer the question of whether or not there is a problem in access to public health care or healthcare more generally. Those are different propositions.
Yeah. Look, I'll leave it there, because you see, the sense I'm getting is an attitude that's being given to this court to say those who can afford and who are privileged should not be touched.
No, Deputy Chief Justice, that's not, with the greatest of respect, if that's the impression that I'm conveying, then that's not the intended impression that I wish to convey, because it's also not the impression that HASA conveys, because HASA talks to how, in its papers, it talks to how, in times of need, including during the COVID crisis, its members have stepped up. It also talks to how its members provide emergency medical care when there's a time of need. HASA is not unsympathetic. But the question that you're putting to me, Deputy Chief Justice, is not one of sympathies. The question is whether or not the Minister can, under the auspices of regulation, compel a private citizen to move somewhere and do something without anything more, without paying them, without offering to pay them, without employing them, without doing anything more. That's the proposition. And HASA says that that idea is not an idea that comports to regulation of the healthcare system. That's something different. But within that, they're very sympathetic about the lack of access.
Thank you very much. Thank you. Questions?
Mr. Leach, I have listened with